Everyone would please be seated. The committee will come to order. I'd like the record to reflect that all 8 members of the subcommittee are present. This hearing of the Adjudicatory Subcommittee of the Committee on Standards of Official Conduct in the matter of Representative Charles B. Rangel will come to order. The Constitution authorizes the House of Representatives to discipline its members. In the House, the Committee on Standards of Official Conduct is charged with recommending and enforcing ethical standards that ensure that members and staff act in a manner befitting that public trust. It is under that authority that we are meeting here today. This hearing is authorized by House Rule 11, Clause 3 and Committee Rule 23. The purpose of this hearing is to determine whether any of the 13 counts included in the statement of alleged violation in the matter of Representative Charles B. Rangel have been proved by clear and convincing evidence. On June 17, 2010, a bipartisan investigative subcommittee of the Committee on Standards of Official Conduct adopted a statement of alleged violation in the matter of Representative Charles B. Rangel. Representative Jean Green chaired the investigative subcommittee. The ranking member of the full committee, Representative Joe Bonner, served as the subcommittee's ranking member. Representative Bobby Scott and Doc Hastings also served on the subcommittee. The investigative subcommittee adopted a statement of alleged violations, which includes 13 counts. For each count, the investigative subcommittee concluded that there was substantial reason to believe that Representative Rangel violated the Code of Conduct or a law, rule, regulation, or other standard of conduct applicable to Representative Rangel's performance of his official duties or the discharge of his official responsibilities as a member of the House of Representatives. The role of an adjudicatory subcommittee is to determine at a hearing whether any count of the statement of alleged violation has been proved by clear and convincing evidence. The purpose of this adjudicatory hearing is to do that. However, it is important to bear in mind that the proceeding is a hearing, not a trial. Attorneys from the committee's nonpartisan professional staff are the moving party in these proceedings. Their role is to make a case for the statement of alleged violation adopted by the investigative subcommittee. At the adjudicatory hearing, the burden of proof rests with committee counsel to establish the facts alleged in each count of the statement of alleged violation by clear and convincing evidence. Representative Rangel will have an opportunity to present his side of the story should he wish to do so. A respondent is not required to present a case in his defense, and should Representative Rangel choose not to present a case, the subcommittee will not and may not draw a negative inference from that fact. As members of the adjudicatory subcommittee, we are neither accusers nor are we defenders of our colleague, Mr. Rangel. It is our job and our duty to act impartially as finders of fact and law. We are honor-bound to do so without regard to partisanship or bias of any sort. We are required to act honestly and fairly based on the evidence presented to us during the adjudicatory hearing. In light of that role, I remind my colleagues that while this hearing is in progress and while the ethics process continues for this matter, we should continue to refrain from commenting on the facts, the law, or any other aspect of this matter. In conducting this hearing, the adjudicatory subcommittee will follow the procedures established by the rules of the committee. The quorum required for the adjudicatory subcommittee to conduct any business is the majority plus 1 or 6 members. If at any time the subcommittee does not have a quorum, the chair may recess the hearing and may direct the clerk to contact the members who are not present. In addition, the chair can recess the hearing at any time as needed. The order of the adjudicatory hearing will be as follows. First, the subcommittee will hear argument on a motion noticed by committee counsel. Each party will have 20 minutes for argument. I would note that unless he is under oath, any statements, questions, and arguments that Representative Rangel makes will not be considered evidence in this matter. Members of the subcommittee will then have an opportunity to ask questions of the parties should they choose under the 5-minute rule. Following a ruling on the motion, committee counsel and Representative Rangel will each be allowed 10 hours to present their case, including the time allotted for opening statements and closing arguments. The order is established by committee rules. First, I would recognize Committee Counsel and then Representative Rangel, who I gather, since he is sitting by himself at the table, may be representing himself for any opening statements they wish to make. Each party will be limited to 1 hour for their opening statements. Each party would then present their case. The order for receiving testimony from witnesses and other pertinent evidence is also established by rule. Committee counsel will present their evidence and call witnesses first. Representative Rangel will have the opportunity to cross-examine witnesses called by committee counsel should he wish to do so. Next, Representative Rangel will have the opportunity to present evidence and call witnesses should he choose to do so. Committee counsel will have the opportunity to cross-examine any witnesses Mr. Rangel calls in his defense. After Representative Rangel finishes his case, committee counsel may ask to present rebuttal witnesses as permitted by the chair. Members of the subcommittee will also have the opportunity to ask questions of each party's witnesses under the 5-minute rule unless otherwise directed by the chair. After all testimony and evidence has been presented, committee counsel and Representative Rangel will each be permitted to make a closing argument. Each party will be limited to 1 hour for their closing argument. Members of the subcommittee will then have the opportunity to ask questions of the parties under the 5-minute rule unless otherwise directed by the chair. At that time, the members of the Adjudicatory Subcommittee will then meet in executive session to consider each count included in the statement of alleged violation. The subcommittee will determine by a majority vote of its members whether each count has been proved. The Adjudicatory Subcommittee would then report its findings to the full committee. If no count is proved, the full committee will prepare a report to the House based upon the report of this subcommittee. On the other hand, if any one or more of the 13 counts in the statement of alleged violations are proved, the full committee will conduct a sanctions hearing to determine what sanction, if any, the committee should recommend to the House. The allegations included of the statement of alleged violations are significant, and we take seriously our obligation to conduct these proceedings fairly, impartially, and with the dignity and decorum befitting any proceeding before the House of Representatives. This is a forum to discharge our responsibilities and our duties as set forth in the rules of the House and the rules of the committee. The adjudicatory hearing will be conducted subject to the rules and decorum of the House of Representatives, and all participants will be required to observe strictly and promptly all evidentiary, procedural, and other rules of the committee and rulings issued in this hearing. As I chair these proceedings, I plan to do so in the fairest way possible to all parties involved, as well as to the House. At this time, I recognize Representative Mike McCall, the ranking member of the subcommittee, for his brief opening remarks.
Thank you, Madam Chair. As I stated at the opening hearing last July, this is an important day, both for Mr. Rangel, for this committee, for the Congress, but most importantly for the American people. And let me be clear, no member of this committee asked for this assignment. Sitting in judgment of a fellow member and colleague is a very difficult thing for all of us to do. But we accept our responsibility here today. We serve for no other reason than to protect the honor, integrity, and credibility of this institution, often referred to as the People's House. The American people's confidence in us is at a historic low. They want their elected representatives held accountable for their actions, just as they are held accountable as private citizens. It is my sincere hope that these public, televised hearings will help increase transparency and accountability and restore much-needed trust to the House as an institution. Our responsibility as judges in this matter is to be fair and impartial. There is no place for presumed guilt before innocence in this process, and there will not be in this case. Hearings of this kind are rare and historic. These hearings follow a 21-month-long bipartisan investigation, an investigation that received sworn testimony from nearly 50 witnesses and over 28,000 pages of documents, an investigation that produced a 13-count statement of alleged violations, and over 500 exhibits that have been placed on the committee's website. These allegations, if proven, would demonstrate that Mr. Rangel violated multiple provisions of the House rules and federal statutes. As judges, we must determine where these allegations were proven by clear and convincing evidence. On numerous occasions, the respondent, Mr. Rangel, has requested public hearings, a right that he is afforded under the committee rules. Today, this hearing affords him the opportunity to be heard. And as judges in this matter, it is our responsibility to make sure the process is both fair and dignified. And as a former federal prosecutor in the Public Integrity Section at the Department of Justice, due process is nothing new to me. It is guaranteed by our Constitution, and it is a responsibility I take very seriously. So as we prepare to hear the evidence against one of our most tenured colleagues in the House, we need to ensure we have done everything we can to assure the American public that we will handle this matter with the utmost professionalism and nonpartisanship that it deserves. We can never forget that public office is a public trust. And with that, I yield back.
Gentleman yields back. Before proceeding, we see that committee counsel is present. Mr. Rangel, are you represented by counsel here today, or are you representing yourself?
Madam Chair, I'd like the opportunity to make a brief statement as to why I'm here without counsel. And I want to recognize that I appreciate that none of you members have asked for this very awkward and sometimes embarrassing responsibility. And I truly believe that the Constitution requires that we have a standard of conduct that's expected of members of Congress, no matter how long they have served. The reason I asked this proceeding to be delayed or postponed is because I am without counsel. This committee has suggested to me by letter that it would be possible for me to set up a legal defense fund. But this was 2 weeks ago. And now the procedure is moving forward before we've had an opportunity to set up that fund. But far more important than that, to me, is a question of due process. Not just for me, but for any member of Congress when accused of anything, they should have a lawyer. On several occasions, I've spoken with chief counsel, I've spoken with the chair, and I have required it. On October 22nd, the chair lady sent me a letter and basically denied me the opportunity to get a lawyer for 3 reasons. One, because this matter has been going on for over 2 years. And because during this period of time, I've had counsel. Well, that is true. But it's not my fault that it took 2 years before the statement of alleged violation was reported. And I'd like to add that during this period of time, my lawyers were charging me while you were investigating. When the charges of counsel became over $2 million, and I could not convince them that I'll be able to pay what one of the lawyers said could be $1 billion for the hearing, they withdrew. The committee knew that they withdrew. So the argument that this has been going on for 2 years, it is accurate, but I don't see how it relates to me not being able to have counsel before you today. The second issue has been raised, and I think Mr. McCall, whose background and experiences know, I have been asking for this matter to be aired. I have been it. But each time that I've asked for a hearing, any of you believe that I was asking for a hearing without counsel? And all I'm doing is asking for the opportunity to have counsel. I still feel strongly that the Congress and the community should know what I have been charged with and what the testimony is. But by the same token, I had hoped that you would do it before the Democratic primary. It would have been helpful if you had done it before the general election. But for whatever reason, when I made my plea on the floor, when I had counsel, that was not done. I might even add that when my opponent and critics were charging me with corruption and allegations of crime, I really had hoped and thought that this committee was not just there to find wrongdoing, but would say that one of your colleagues, there was no evidence of criminal activity, there was no self-dealing, there was no bribery. I just thought fairness would dictate that this would be said. Maybe I'm not entitled to it, but I certainly didn't get it. And so the whole idea that I'm denied counsel because I've been screaming for a hearing, that really doesn't take away from the argument is that I am being denied the right to have a lawyer right now because I don't have the opportunity to have a legal defense fund set up, and because I can't afford another $1 million and can't even promise that to counsel. But quite frankly, committee members, it's the third reason that the chair has given to me that pains me the most as to why I'm not entitled to a delay. I'm not entitled to a postponement because this matter perhaps could not be resolved before the end of this session of Congress. Can you tell me under what theory of fairness would dictate that I be denied due process, that I be denied an attorney because there is going to be the end of this session? When we know that I would be entitled if we had more time. That's what you're saying. What does it mean that we're having Thanksgiving and Christmas and perhaps congressional trips preparing for the next Congress? How far does this go to a person not having counsel, not having due process because we don't have time? Well, I think we ought to find the time. I'm prepared to stay here to get counsel and to have a hearing on this. What prevents us from doing it? And then to add that, as I stand before you, I have no idea as to how counsel intends to proceed. A week ago, 80 pages of what could be considered summary judgment, I think would indicate that this committee may not be prepared to call witnesses. That this committee would ask that a judgment be made based on admissions and exhibits. I've had no lawyer to look at this, but to me it just sounds unfair to say that because of limitations of time, we won't even go through the process of calling witnesses. I hope that you interrupt me and tell me, counsel, that this is not so. But on the other hand, if it didn't want to have the appearance of fairness, Mr. McCall said that you've spoken with 40 witnesses or more, that there's 30,000 pages of testimony. Am I entitled to know what they testified to? I've been given deadlines in terms of how to respond, what witnesses I would want to subpoena. But I have been denied that opportunity. If the chair is suggesting that I conclude my remarks, then I would do that. But I would want you to know that I don't think it's fair that I participate in any type of proceeding if in fact what you are basically telling me that the political calendar will not allow you enough counsel this crucial point in my life. 50 years of public service is on the line. I truly believe that I'm not being treated fairly and that history will dictate that, notwithstanding the political calendar, I am entitled to a lawyer during this proceeding. I want to thank you for your courtesy. There's a lot of pain that I feel because I fought in the wars. I've prosecuted in the U.S. Attorney's Office. I've served as a legislator in the state. I am so proud of my record in the Congress. I love this Congress. I love this country. I think I'm entitled to more than is being suggested today. Thank you so much for this courtesy.
Thank you, Mr. Rangel. Before turning to committee counsel, I would just note for the record, and I will put into the record the exchange referred to by Mr. Rangel, so this will not be a mystery to the public. But I would note that we were advised that Mr. Rangel's counsel withdrew a little over a month ago, and further counsel has not been retained, and that the committee has indicated an intent to proceed today.
Madam Chair, would it be appropriate for me to ask you a question?
Certainly.
Are you going to construe Mr. Rangel's statements over the last 10 minutes? And I listened to what he had to say very carefully, and let me say that it also troubles me that he is before the committee today without counsel. Are we going to consider his statement as a motion to continue this hearing?
Is that a motion to continue, Mr. Rangel?
I don't know whether first of all, my role here is as a respondent, and I am not here representing myself. I've been a lawyer long enough to know that it is very, very unwise for any person, a lawyer or a judge, to be his own lawyer at a proceeding like this. So I'm not in position to make a motion unless we're talking about fairness, unless we're talking about someone contradicting everything I've said, unless any member has any question to ask of me.
Thank you.
And notwithstanding the fact that you're submitting your letter for the record, if there's anything I've said about that letter and all of the conversations we've had, I would think that notwithstanding procedure, Judge Butterfield, that fairness would allow you to say that this is a statement of how I feel as a person, as a member of Congress, and as the citizens that's begging for due process. You can call it a motion, and I can't quite frankly answer that question.
We appreciate that, Mr. Rangel. We will turn now to committee counsel, Mr. Chisholm, to introduce your team and to make your motion for the admission of evidence.
Madam Chair, Ranking Member McCall, members of the subcommittee, Representative Rangel. My name is Blake Chisholm. I am the Chief Counsel for the committee. To my right is Deborah Morris, counsel to the committee, and to my left is Donald Sherman, also counsel to the committee. At this time, Madam Chair, I would move to introduce Exhibits 1 through 549 into the record.
Is there objection?
Well, Madam Chair, if it pleases, with all due respect, I'm not in a position to pass judgment on what counsel is about to do. I've never known that this proceeding even existed as summary judgment, if that's what he's about to do. Any lawyer that I've talked with have said that this committee has no history at all.
If I may interrupt, Mr. Rangel,
Yes.
just to clarify this. There is, we were noticed, as were you, of this motion. I would like to make clear, however, that we will hear the motion, the argument from the committee counsel, and whatever argument you may choose to make, but that if you wish to be heard in an opening statement, if you wish to proceed with witnesses, we will hold any ruling on that motion in abeyance so that if you wish to be heard, we will hear you.
I appreciate the chair's statement. Would that include the right for me to have a lawyer?
You may hire whoever you wish as a lawyer. That is up to you.
Well, you've seen the record, 2 million already, and I've been advised that this hearing could cost me another million. You've offered me the opportunity to have a legal defense fund, which would allow perhaps a lawyer to come into the case. If that's what you're saying, there is nothing I would not yield to for that purpose. But you know that if you're saying that we can't move forward, then that restricts me from getting a lawyer, not only financially, but the legal defense fund that you suggested I would have no meaning at all. If what you're saying, if there's anything I can do within the rules of the committee that would allow me to move forward with this.
Thank you,
not
Ms.
to object to just the procedure, but I did not know until a week ago that this 80-page would be the way you intended to judge my conduct. A week ago. So I can listen to what he is saying, but does this mean that he is going into this procedure, that I don't have counsel to guide me?
If I may, Mr. Rangel, if you could be seated. For clarification, the respondent has inquired of the committee whether a fund could be created where contributions could be made for legal representation, and has been advised by the committee that that is permissible. However, the retention of counsel is up to the respondent, whether you're to hire it at your own expense, through your campaign committee, or through a fund is your decision, not the committee's decision.
All I'm asking, if I agree with you 100%, Madam Chair, all I'm asking for is the time to get counsel. I have lawyers from Washington, D.C. and New York are willing to give me free counsel to be able to come here because they don't think I've been treated fairly, and yet they say that if they do that, it's a gift and violates all of the laws. I heard that perhaps they can do it at reduced fees or fair fees. If only we had time to develop the committee. You tell me that I don't have time to do that. And so while you tell me that, yes, I can hire anybody, get anybody, not have a lawyer, you're also saying, and that's the third part of your letter, that time does not permit this matter to be concluded before the end of this session. And that's the nuts and bolts of what we're talking about. You tell me all of the things I could do, but you're not going to give me time to do it. I think no one can say that that's not the way this ends up. Yes, I can do these things, but you have to conclude this now and the next day. And my reputation, 50 years of public service, has to suffer because this committee has concluded that you must conclude this matter before this Congress ends. And all I'm asking for is time to get counsel. Time to get counsel. And you're saying now, I think, that you denied it before and you're denying it now.
I gather that you do not object to the admission of the evidence that has been proffered by committee counsel?
Well,
and therefore the admission...
I object to the proceeding, and I, with all due respect, since I don't have counsel to advise me, I'm going to have to excuse myself from these proceedings because I have no idea what this man has put together over 2 years that was given to me last week. And I just hope that the history of this committee, in terms of fairness, will be judged for what it is. So, with all due respect, and recognizing how awkward it is for the members of this committee, as colleagues and someone that would like to preserve the right of members to be judged by their peers with counsel, I respectfully remove myself from these.
Madam Chair, before the respondent leaves, may I ask the chair an additional question?
Certainly.
Even though the respondent did not specifically make a motion to continue this hearing, I deem his comments to be a motion to continue. And I would like this committee to seriously consider a motion to continue. I would like for us to do it in executive session and discuss among ourselves what the respondent has said, because I take his contentions very seriously. I served as a judge in my state for 15 years, and I know the importance of counsel, especially in this environment. And so I'm going to ask that we deem his statements to be a motion to continue and that we discuss it in executive session.
All right, that is a request from one member to have a discussion on the, well, it'll be your motion to
I'll make a motion to continue the matter. and
continue
ask
the
that
matter.
We take it up in executive session.
we will go into our closed session and have a brief discussion, and then we will return.
Was there a second to the motion?
Yes, there was.
There was a second to the motion. All right.